suspect is in court once again today. We have learned his attorneys plan to argue for his release. So joining us now, criminal defense attorney Joseph Tully with the latest on this one. Joseph, this is not his first court appearance, but this is a very important one.
Yes, this is a detention hearing. So just because you get accused, just because you get arrested, doesn't mean that you have to go to jail. We can't pre-punish people for crimes that they're accused of. So that's the justification for everybody having a right to bail. Now, at today's detention hearing, the judge needs to determine if there can be reasonable measures taken to ensure his future appearance and whether or not his release would be a danger to the community. Whether or not he'll show up to court, the government is conceding. They're not worried about him taking off. They're not saying he's a flight risk. They are saying he's a danger, just based upon the circumstances of what happened or what he's accused of. Explosive objects, people could have gotten killed. This is something kind of retaliation on a political level, they're arguing. On the other hand, the defense side, they're saying, listen, he's 30 years old. He has no criminal record. He's on the autistic spectrum. He has OCD. He's never been in trouble before. Reasonable conditions such as ankle monitoring or supervised supervision can take care of any danger that the court is concerned about.
Now, we know in court filings that he allegedly confessed, but he was on the lam basically for 5 years. So for the defense to argue for his release, how likely is it that a judge will agree with that?
So to answer this question best, I would take off my attorney hat. I would just approach it as a regular person. Do you think a judge is going to let somebody go who is accused of placing bombs outside the political party's offices? And I don't think so. I think we've seen there's a climate where people are starting to get angry at judges for releasing people, and they're perceiving that it is being soft on crime. If I put my attorney hat on, then I actually see that this is a much closer call in terms of the law here and in terms of what the judge has to do. Again, we're dealing with somebody who is 30 years old, no criminal record, nothing bad happened here. And yes, he's saying that he meant to blow it up, but then he's also saying he was relieved. So, really, could this situation be resolved with this individual kid, being monitored, being supervised, GPS? The answer is yes. I don't think a judge is going to take it, though. I think it's political hot potato.
Joseph, I love when you put on your real person hat and your attorney hat because it provides such excellent perspective, because a lot of people are saying, wait, this was such a far-reaching investigation. It took 5 years to get this suspect. Now you're going to let him go, whether it's on monitored release or ankle monitor. It seems like a risky move. What are the next steps here should the judge decide to keep him behind bars?
So the judge, according to some reporting that I've seen, said he's not going to release a decision today, but he will have one shortly released. Again, you and I are on the same page. I don't think he's going to release him. The next step after that is a preliminary hearing. There are some procedural issues that the courts still need to work out, but a preliminary hearing, everybody knows what a jury trial is. Think of that as a movie. Yeah. You see all the main characters, you see all the plots and subplots. A preliminary hearing is like a movie preview. It's not 2 hours long, it's 2 minutes long, and you get a skeletal outline of the prosecution's case. That would be the next step after this detention issue is resolved.
All right, still lots more to come, and we'll be watching. Joseph Tully, thank you so much, as always. Happy New Year to you.
Thank you. Happy New Year.
All right.